start by restoring Rule 17 with the said limitation. The Parliament appears to be much concerned about misusing the provision quite often by the lawyers, may be at the instance of their parties invoking one time or other invariably in every matter. It is for the said reason the above mentioned proviso was inserted to Rule 17. The intention of the Parliament, therefore, is that if any party proposes to amend his pleadings, he has to be prompt in doing so, and not later than the commencement of the trial. At the same time, it appears that the Parliament visualized the fact that there may be justifiable cases where, despite exercising due diligence, the party could not be able to make an application for amendment even after commencement of the trial. Thus, from the acts of the Parliament, by omitting Rule 17 and restoring back the same provision with a proviso, it is to be necessarily understood that totally dispensing with the provisions relating to amendment cannot be contemplated, because the parties on their counsel are bound to commit mistakes, and at times when the case progresses, it may become necessary for a party to demonstrate his case effectively for the purpose of proper and complete adjudication, and for that purpose at any stage of the case amendment would become necessary. Therefore, what is to be curtailed is the attitude of the parties' counsel in filing amendment applications to protract the litigation, or to harass the opposite party, or to defeat the right of a party which had already accrued. But when once the court arrives at the conclusion that the application for amendment is genuinely made and out of necessity, and with a view to remove any ambiguity, the court shall be liberal in granting amendment at any stage of the proceedings. The proviso, therefore, is only a measure of caution against dilatory tactics, but the real question to be considered is the genuineness of the application made seeking amendment. The delay can be compensated by money, but shall not come in the way of adjudicating the rights of the parties properly. Therefore, if the amendment petition is filed after the trial had begun, it is obligatory on the part of the party seeking amendment to satisfy the court that, in spite of due diligence, he could not make the application at appropriate time. The court can allow the amendment petition.